From July 1, we in India are governed by new criminal laws. We have been told that India could have become a police state. So, for Frontline Conversations, I thought we, the people of India, should try and find out what it's really about. So, I'm speaking to one of India's best criminal defense lawyers, senior advocate Rebecca John, who really deals with criminal law. And I'm going to ask her, I'm starting off this conversation, Rebecca, are we now a police state?
That's a complicated question, Saba, but the three important changes in what is now called the Bharatiya Nagarik Suraksha Sanhita, which is earlier the CRPC,
yes,
and what was earlier the IPC. One, the inclusion of certain provisions of the UAPA within the penal code.
Okay.
Two, the inclusion of certain provisions of MACOCA, the Maharashtra Crime Control Order, which was applicable even to states like Delhi,
right,
within the penal statute. And three, and this is what perhaps is disturbing a lot of people, the entire procedure governing arrest and remand.
yes,
As you are aware, a person who is arrested in India has to be produced before a magistrate within 24 hours. That hasn't changed.
right,
The magistrate will then remand the accused person, if not released on bail, to a period of 15 days. And that period will go up to a maximum period of 60 or 90 days, depending upon the gravity of the offense.
okay,
So this was a pretty stable kind of system that we had
yes,
over the years. What was clear from the reading of the earlier remand provisions was that during the first 15 days, it was interchangeable custody, where the magistrate, on the asking of the police, could pass an order for police custody remand.
okay,
It could be for a period of 3 days, 10 days, or the entire period of 15 days.
Right.
But that was limited to the first 15 days. After the first 15 days were over, then the magistrate compulsorily had to remand the accused to police custody, to judicial custody, and there was going
which
to be
means
no
jail,
fun,
which means
which
you
meant
go to jail.
any jail, which
Right.
was under the control of the court.
yeah,
The idea, of course, was to discourage excessive custody with the police, given the fact that the police has a slightly shady track record in the country. Now what has happened is there has been a change in that formulation. Once arrested, you're still produced before a magistrate. You still cannot be remanded beyond 15 days at a time. So the tranches remain the same.
okay,
And but what has changed under the new law is that a person can be remanded to police custody not just in the first 15 days, but if the charge sheet has to be filed within 60 days, then during the first 40 days, there can be staggered remands of 2, 3, 4, 5, 6 days each of police custody.
but not more than 15 days.
Not totaling not more than 15
So
days.
that's a clarification, Rebecca, because as
Now,
a lay person,
there is a caveat to that, and I'll
Yeah.
come to that.
okay,
And if the charge sheet has to be filed within 90 days, then the staggered police custody can be for a period of 60 days.
Okay.
Now, this itself, to my mind, is excessive. Because what finished after the first 15 days, you are now keeping people in custody in a state of high anxiety for a period of 40 days or 60 days, because the police can come back and seek your custody and completion of their 15-day period over a period of 40 or 60 days.
okay,
It'll have ramifications when it comes to bail applications that we advise clients to move. So ordinarily we used to tell clients that if the police says we no longer need you in custody, you can be sent to judicial custody, that became a ground to seek bail. But where there is staggered custody for 40 or 60 days, obviously courts will be somewhat circumspect before entertaining applications for bail. Bails, in any case, in India, are the biggest. Getting bail is a big challenge in any event in India. Now, what has made this a little complex is the wording of Section 187 of the Bharatiya Nyaya Suraksha Sanhita, particularly subsection 3. Now, the earlier law, the corresponding law to this was Section 167. And 167, the third proviso, very clearly said that the magistrate may authorize the detention of an accused person, and the crucial words were otherwise than in the detention of the police.
Okay.
Right? Which meant outside
of the police
for a
custody.
maximum period of 90 or 60 days.
Okay.
Now, these crucial words, otherwise than in the detention of the police, has been deleted from subsection 3, leading some analysts to say that perhaps police custody can extend up to 90 days or up to 60 days, depending upon the gravity of the offense. It is, of course, in complete contradiction to what has been said in subsection 2. And I understand that there has been a clarification from the Home Minister on the floor of Parliament, on the very first day of Parliament, where he said that the police cannot have extended custody beyond 15 days, and that those 15 days would be in terms of subsection 2. Nonetheless, the ambiguity with which subsection 3 has been worded will need to be corrected soon, if that is the intent of Parliament, to at least limit the period of police custody for a total of 15 days, albeit in a tranched manner between the first day of remand to 40 days or the first day of remand to 60 days. So the regime to that extent has changed, because it's no longer the first 15 days. It can be any time between the first remand and 40 days, any time between the first remand and 60 days. My assumption is that what the Home Minister said on the floor of the House would apply to subsection 3, and the deletion of the words otherwise than in police custody in subsection 3 will not lead to the interpretation that the police can get custody beyond 15 days in total.
Okay. The point is, laws have to be clear. That there is so much confusion here. How would there be clarification? Does it have to come through legislation, amendments, or would it come from the higher judiciary?
So it can be a combination of both.
Okay.
You see, these were some of the defects which, even at the time when the draft was out, many of us had sent representations to the standing committee, which was looking into these gaps. Some of the gaps were filled up.
Okay.
But this has been left ambiguous. So either a superior court or constitutional court will have to interpret the slight contradiction between subsection 2 and subsection 3, or by virtue of an amendment, the words that have been deleted will have to be brought back. But regardless of that, I am saying that the increase of the period, although it's only 15 days, but the use of those 15 days during the first 40 or 60 days, as the case may be, is itself worrying. Because as you know, most democratic countries which are governed by constitutional law don't have this concept of police custody remand. We kept it to 15 days. Even that was felt to be excessive sometimes. Now you're allowing the police to take custody of a person who is accused of an offense in tranches over 40 days or 60 days. That, to my mind, is problematic.
Okay. So, do you see any improvement in the new criminal laws? Has anything improved for a criminal defense lawyer from the rights of the people? Is there anything that is clarified, that is better?
So there has been, let me tell you one thing. While there's much to be said about the fact that 3 new criminal laws have replaced the older laws, other than the title and some of the issues that I've flagged, much of the old Indian Penal Code, the old Code of Criminal Procedure, and of course the Indian Evidence Act remain the same.
Okay.
What has happened is amalgamation of sections. So where there were separate sections for separate definitions or offences, many of these have been amalgamated into one section to give an appearance of change. But if you look at it word by word, section by section, the placement of sections may have changed, but the content is largely the same,
Right.
other than the few things that I have flagged.
You have flagged that.
I have flagged. So to say that there has been an overhaul of the old penal code or the old CRPC or the Evidence Act would be stretching credibility a bit. That hasn't happened. I had once used the phrase in connection with these laws, this old wine in new bottles. And that's all that has happened, because the placement has changed of sections. What used to be murder 302 is now 101. 420 no longer remains 420.
Yeah.
So all of that has happened, which will cause a world of pain to those who practice criminal law, to those who have to give judgments, even to ordinary people. Because if that was the only reason why this was brought in, then it was completely unnecessary. But yes, there has been some change with respect to police custody, remand, etc., which I have flagged. More serious, I think, is the invocation of provisions of UAPA, provisions of MACOCA, even provisions of PMLA into the penal statute. I have not understood the rationale behind that, because either the special statutes have to go and this can remain within the penal code, or these have to be taken away because the special statutes remain.
So can I ask you a question? On the one hand, you are saying that there is actually, it's old wine in new bottle, but are these laws intended to actually crush dissent a little more easily?
I would think
because there is this whole language which about sovereignty of the country, speaking about that. Could you elaborate on that? And does that tie up with the point you have about UAPA and MACOCA?
So as far as penal provisions are concerned, there is a lot of emphasis on speech, on what they consider, on what is considered to be speaking against the sovereignty and integrity of India. All of which used to be materials that were prosecutable under the UAPA. Now bringing it into the penal statute and allowing a superintendent of police to decide which of the two statutes would apply in a particular case, I think is arbitrary exercise of power. There was no need for that. We were, of course, arguing that UAPA itself is draconian, PMLA itself is draconian, its bail provisions are draconian. And why should you put people in jail for years and years on end just because they have a particular thought process? Now you brought that into the penal code, and into the new penal code, and that makes it a little problematic. Sedition, which used to be 124A, has been repackaged, and has been brought back into this court in the teeth of a Supreme Court order, which had actually said it's time that sedition should go lock, stock and barrel. The Law Commission had recommended it, and yet Parliament, in its wisdom, decided to repackage it and reintroduce it in the same form in the penal code. There are many provisions which have been tinkered with, which go against the letter and spirit of Supreme Court orders.
Okay.
So yes, coming back to your earlier question, I think what one can assess on a reading of the penal provisions is the fact that a lot of premium has been given to speech-related offences and to this whole business about sovereignty and integrity of India, and any action. Now, while it can be argued that anything said, done, or any terrorist act which goes to which is intended to break up the sovereignty and integrity of India is culpable, that is true. But you already have a special law taking care of it, right? Which you've expanded to include speech-related offences. I don't know the rationale of bringing those provisions within
Does
the
this
penal.
mean that, let's say, anyone operating within Kashmir is now even more at danger of being prosecuted for the state by expressing a view, or someone in the northeast or anywhere in India, or even a protest? Can such, let's say you could not have arrested protesters under UAPA, though that has happened in India in recent times, but let's
Yes.
say that even the sort of protests that we witnessed, the farmers
Yes.
or Shaheen Bagh, that there are sections of the law
Yes.
which could have been applied,
Yes.
and people could have been. I'm not clear what is the years of punishment, what is it that they confront, what is the how much evidence does the state have to have, what. I mean, it's all going to be new,
So
right?
that it's all going to be new, and to my mind they have lifted verbatim provisions from Makoka as well as UAPA into the new penal law,
Okay.
and so whatever applied there would apply
Okay.
here. The only thing, and I hope by saying this we don't get a parallel amendment, in UAPA, in Makoka, in PMLA, there are special stringent conditions for bail, and unless you pass what is known as a twin test, you are not entitled to
Okay.
bail. There are no parallel provisions that prohibit bail in the IPC, although these provisions have
Okay.
been lifted
Right.
from UAPA, Makoka, and PMLA. That, to my mind, is a good thing, because the embargoes that you found prohibiting or limiting the exercise of bail, the right to bail, both under 43D5 of UAPA, under Section 45 of PMLA, are missing from the penal
Okay.
code. So, in that sense, those limitations not being there is perhaps a good thing.
Okay, okay. There's a stringent punishment apparently for mob lynching, punishable by death. I'm just seeing generalities that I've read in the media. Is that, I mean, how?
So, Saba, this again is what if mob lynching results in death? It is murder. Murder
Was
is
already-
punishable with life or death.
Yeah.
Right? What the statute has done is recognize a type of murder, like there's dowry death,
Yes.
etc.
Okay.
But there are no parallel presumptions like there is for dowry death. So, if they wanted to make mob lynching into a robust offense, there could have been some sections in the new CRPC or the Evidence Act where presumptions could have acted against an accused
Right.
person. In dowry, for example, in dowry death, there are a whole lot of presumptions. Marriage if it happened within 7 years of marriage, if it is in connection with dowry, it will be assumed that there was a dowry demand, etc., etc. There are no parallel presumptions
Okay.
when it comes to mob lynching. So you've created an offense which is part of the larger offense of murder, but you haven't made it any simpler for prosecutions.
Okay.
And therefore, all I can say is that it is another. I mean, whether you are
So if you
whether you are stabbed or you are shot dead through a bullet injury, or it is a mob lynching
Or you're
incident,
beaten.
or you're beaten, in the end, if death occurs, it is murder.
It is murder, and that's how it will be prosecuted,
That is
if
how
at
it,
all.
That's how it
If
will
at
be.
all.
If at all, yes.
If at all.
So there is, of course, a separate section even with respect to mob lynching, which doesn't result in death but grievous hurt.
Okay.
But again, the punishment remains the same as with respect to general grievous hurt.
Okay.
And there are no parallel
So
presumptions.
there's actually nothing new which has been created for the phenomena of mob lynching.
Not to emphasize that it is a different type of crime which requires a different type of prosecution. That has not been done.
Then there's one clause 69 of the BNS, and here I'm a lay person, which says penalizes sexual intercourse through deceitful means.
Yes.
This includes false promise of employment or promise of marriage after suppressing identity. So I presume the suppressing identity means a Muslim male seducing a woman pretending to be a Hindu.
Yes, you're absolutely right.
But then what is this? But does this not imply that any breakdown of any relationship
Yes.
can lead to prosecution of the male? Or
Yes, of
so
course.
can you just elaborate on
So,
this?
promise to marry was being, I mean, there were cases that we were getting even under the old penal law on grounds of a person, on grounds of a woman entering into sexual relations with a person on the promise to marry, which later on proved to be false. Jurisprudentially, there was a lot of discomfort with this subset of offenses because, you know, what you saw generally was a long relationship, a relationship which was presumably with consent,
Yes.
and then something happening, and it resulted in, and there was a breakdown of that relationship. Now, simply because a relationship breaks down, you can't post facto call it rape. And somehow one felt that it kind of denied agency to a woman, where it put marriage at a premium.
Yes.
And it also didn't give the right to a man after being in a relationship for a while to say that this is not working.
Yes.
And then having to be prosecuted for rape would be a little harsh.
Have those laws become harsher now?
Well, they've introduced a new section. They've codified it for
Okay,
the first
okay.
time. It wasn't there earlier. And now they don't even call it rape. What they say is that you have sexual intercourse by employing deceitful means.
So this deceitful means, I mean, because it's
Right.
not.
So the section, in fact, very clearly says that such sexual intercourse not amounting to the offense of rape. So what they seek to punish is not sexual intercourse which amounts to rape, but sexual intercourse which is based on some deceit that has been carried out. Obviously, if you were to look deeper into this provision, the typical promise to marry cases would come into it. But I fear that a lot of interfaith marriages may also be subjected to prosecutions if they don't work out, on the ground that this man told me he belonged to this caste or this community. It turns out that he was lying, and as you know, it's sometimes very difficult to prove that none of that happened.
Yes.
So I think there can be a fair amount of misuse as far as this provision is concerned.
Isn't there a lot of confusion because states seem to have their own versions of this so-called love jihad, quote unquote laws? Am I right about that? It's
Absolutely.
not the standard
And
all
even
India.
with respect to those laws, it's my view that adult consensual relationships must never come within the purview of state control.
Right.
And for the state to be monitoring these kind of relationships is not right. And now to have this codified provision, I think you'll have a lot of prosecutions under Section 69.
Okay. Rebecca, there's been commentary about the FIR, that it's now more anti-people, more against the poor, the rules of the. Can you just explain what has actually changed? The first information report, when I go, or a poor man goes, a Dalit goes, an Adivasi goes, a Muslim goes to the Thana and tries to register a report.
Yes.
How does their life become harder? Or it does not, or it's exactly the same, which was not easy to begin with.
So let me just tell you, again, this is a problematic provision because it is in the teeth of a judgment of the Supreme Court called Lalita Kumari versus State. Now, in Lalita Kumari, the Supreme Court said that the police has no business sitting on complaints. If a cognizable offence is made out, the police must register an FIR. Now, what the new law says is that the police has the right to conduct a preliminary inquiry before coming to the determination that a cognizable offence is made out or not. That preliminary inquiry must be conducted within 15 days. But the point is, you're giving leverage to the police to come out and say that we've done an inquiry, we found your complaint to be false. So how does that merge with the earlier judgment of the Supreme Court, which was a Constitution bench judgment of the Supreme Court, which said if a cognizable offence is made out, you are nobody at that stage to test the veracity or otherwise of the complaint. That will be done during investigation. If you found that the elements of the offence are not made out, you will not file a charge sheet, you will file a closure report. But you have to allow the complainant the right to get her FIR registered, and once it's registered, you follow the investigative process. Now you've introduced and you have statutorily you have statutorily allowed the police to conduct a preliminary inquiry prior to the registration of the
doesn't
FIR.
this create a problem for all vulnerable sections of society? How will they ever register an FIR?
It will create a problem for all vulnerable sections of society. It will give a handle to all privileged sections of society to ensure that the police conducts a preliminary inquiry and somehow reaches the conclusion that no offence is made out. I think this kind of power should not be vested with the police, and the old law should come back where the police must register an FIR in the first place. As I said, there is a whole investigative process. The police, after registration of the FIR, if it finds material which is contrary to the contents of the FIR, or where it finds that the FIR is not, the ingredients are not made out, it can always file a closure report and say that the investigation has not substantiated the allegations or has not corroborated the allegations meant in the FIR. So I think this is also a provision which can lead to misuse.
Misuse, I mean, to my mind, this is staggeringly, because when you look at vulnerable people, they are so loath to even file an FIR. And this just makes it impossible for them to do so.
It will also give, so what is the protocol that the police will follow in those 15 days when it's conducted?
Is there any clarity on that?
No clarity. Will the complainant have to go back and forth to justify the ingredients of their complaint? Now, if the person is vulnerable, if a person is a woman, and there's real danger that if the FIR is not immediately registered, and as you know, timing is very important in criminal law. The more time you waste, the weaker the case becomes. And I think this was not required. And the police, by giving the police this power to conduct a preliminary inquiry, which is now it's codified as part of law. You have opened a hornet's nest, and it will lead to more confusion than betterment of lives of people.
It's not just vulnerable sections; it's also gender. Imagine any woman trying to lodge a complaint against her husband, and with a male police officer, and he's going to tell the husband that your wife has come to the Thana to launch a complaint. It sounds terrifying to me, the implications. So can that woman never even file a complaint that he's beating me up at home? The Thana guy can go to the husband. Am I wrong in this sort of imaginary?
No, so I mean, of course, obviously, if there's a murder or something like that, the police is not going to conduct a preliminary inquiry where the offence is apparent and it's writ large. So it would depend it would depend from offence to offence to offence, and just because the police decides to register an FIR without an inquiry, it would not make the FIR any less credible. So the police has the option not to conduct that inquiry. But should it choose to conduct, see, the point is you are giving the police the option to delay the registration of the FIR. And that in a country like India is problematic. They can choose not to use that period for preliminary inquiry because they can see for themselves that an offence has clearly been committed. And they can straight away register the FIR. But giving them that option was I think, unnecessary.
You know, Rebecca, you sort of fought all sorts of cases and you have a spectacular career as a criminal defense lawyer, but does the confusion here also make it possible for you to use the confusion to help get some clients off with these laws? Is there, I mean, we have basically talked about people's rights, dissent, but let's just say there is a crime, you're defending that person. Does the confusion here
Of course it does.
It does.
Of
Explain to
course
me
it
how
does.
that works.
These are not necessarily offenses against the human body, but a lot of cases like cheating or breach of trust, sometimes the facts are quite different from what is stated in the FIR. And had a preliminary inquiry been conducted, those true facts would have compelled the police not to register an FIR.
Okay.
So there have been times when we have stated that, exercise, and even Lalita Kumari, by the way, says that in appropriate cases, you have the right to conduct a preliminary inquiry.
Okay, right.
So this provision must be used judiciously. It must be used in appropriate cases and not across the board. I would say that where you are alleging financial misdemeanor or some kind of allegations of cheating between two business partners or something like that, it makes sense for the police to do a preliminary inquiry to check the veracity of the complaint. But particularly with respect to offenses against the human body, I don't think that should be allowed to be used.
Okay. So is there going to be a lot of...
Let me tell you another provision,
Okay.
which I find quite spectacular. So in criminal law, you can either take the police route by going to the police station and getting your FIR registered, or if the police is not registering the FIR, or for reasons that you have you don't trust the police, you want to go to the court, then that second option is available to an accused person, to a complainant. Instead of going to the police station, can straight away go to a magistrate, and with a complaint, and that is known as a complaint case procedure. The magistrate will then summon the person concerned for his or her evidence, and based on the allegations made in the complaint and the evidence recorded, will decide to summon the accused or not. That's what we call the complaint case procedure. As robust as the police procedure. What this new law has done, and I am struggling to find the reason why they have done it, is that at the time when a litigant goes to a magistrate's court with a complaint, the magistrate is now obliged to issue notice to the accused, the proposed accused, to hear his or her version before it decides to proceed with the case. Now that's absurd, because that is the accused comes much later. In a complaint, when a complaint case procedure is followed, a complaint is filed, the magistrate takes cognizance of the offence, the magistrate immediately asks the complainant to testify before court and bring his or her witnesses in support of the allegations.
I get it.
This is called the pre-summoning evidence. Once that's done, based on what is there on the file, the magistrate proceeds to summon the accused or dismiss the complaint. Now, if you have to hear the accused at the stage of taking cognizance, then you've defeated that process completely. You've muddied the water to such an extent, I don't know how you can move beyond the initial stage to the stage where the complainant is allowed to prove his or her case, at least for purposes of summoning. So that's again a very peculiar provision, and I don't quite know the rationale why that provision has come about.
So now you'll have to struggle through all of this.
Yes.
And you were telling me what the Evidence Act has not been modified.
Except for, again, placement of sections and amalgamations.
Because the Home Minister said in the Parliament that there will be a lot more use of forensic evidence. And so I was just wondering, do we use a lot of forensics in India?
I don't know about the quality of the forensic evidence. That's another story altogether. But in every case, particularly in, so if it's a forgery, your handwriting is taken, it's part of investigative protocol, it's sent to the forensic science laboratory for comparison with your admitted handwriting. Voice samples are taken with respect to the whole regime relating to postmortems and other such things. It's all based on forensics. So this is nothing new that is introduced.
It's already there.
It's already there. That regime is already there. Again, simply saying that this is going to be more forensic based is not enough, because we've been crying hoarse that there are very few central forensic science or state forensic science laboratories. And therefore, it takes sometimes 6 months to a year for reports to come from these laboratories. And despite court orders, no reports come because they are so terribly overworked. So, it's one thing to say we are forensic based. You were always forensic based. You always had forensic science as an element of your cases. But where are the labs? And in the absence of labs, and just 3 or 4 labs across the country, or very few labs, and the quantum of cases, it doesn't really make good that assertion.
Right.
Because if you are going to take years for reports to come, the case anyway loses its steam.
Yeah.
Likewise, there are a whole lot of timelines which are given at the end of it. You know, charges must be framed within a particular period of time, etc., etc. Where are the judges? Where is the infrastructure?
Right.
So, giving timelines in the absence of infrastructure and additional judges, we always had some timelines even in the past. It will be followed in breach.
So are we sort of making, I've always, like the trial by Franz Kafka.
Exactly.
The guy never knows what he's accused of. So I've always felt that the criminal justice system is like Kafka is for many Indians.
Yes.
And especially when I think of a case like Omar Khalid, I have no idea. He's just one example, and there are so many unknown people who are stuck there not for years and years. That why is this person being kept in jail year after year after year? But so many Indians face that. Does it just complicate their life more?
I think we specialize in tokenism. And so we want to give something to our people to say that we've changed the laws, it is going to make a lot of difference. Remember, after Nirbhaya, there was a huge amendment which was brought in 2013. Did anything change? We still had as many rape cases happening on a daily basis. The Vishaka guidelines were brought in, then an act was brought in, has sexual harassment reduced.
Yeah.
So it's not enough to say we've tinkered with the law here or there. If you've introduced provisions which are beneficial to the people, that's very good. But what you haven't done parallelly is to improve infrastructure. Go to any trial court in a city like Delhi, which is much, much, much better than large tracts of this country.
Right.
Any magistrate's court, on an average, the magistrate deals with 100 cases a day.
My God.
Now, unless you have more courts and more judges, the justice delivery system will not be able to follow these timelines. It's just humanly impossible. Put yourself in that magistrate's position. It's not possible to give the same kind of attention to every case which demands your undivided attention.
Absolutely.
Go to a sessions court which deals with murder case, dacoity cases, the more serious cases. Most of them struggle with their list every day. Don't go very far. Go to the Delhi High Court and look at the daily list, the daily cause list. It's almost impossible for any court to finish their daily cause list. So unless vacancies are filled up, unless you have more judges on the ground level, unless you have more courtrooms with the necessary infrastructure, all of this will become meaningless after a point, and you'll still have the same old tariq pe tariq criticism which is leveled against our criminal justice system. The problem is not that our judges do not work or don't want to work. The problem is that they're overwhelmed with cases. And, there are many days when as counsels we wait till 4:30 and our case has not been called out.
Even though you're listed.
Even though we are listed on the list of the day, our case is not called out. Now, the judges have to get up at a particular time because they have orders to sign. They have to read the files of the next day. So, somewhere, everyone, all the stakeholders have to come together and see what has to be done about this pendency. Because so long as you have this pendency, and then in the teeth of that pendency you say within 3 months or within 60 days the order on charge must be pronounced, that looks very nice on paper, but it is completely unenforceable.
Rebecca, on that note, I hope I've covered most of the main points.
Yes.
Because you understand those laws, and I'm just like most citizens of India, we're just trying to understand it.
Yes.
But that was absolutely illuminating, and thank you so much.
Thank you.
For being part of Frontline Conversations.
Thank you.
Thank
And
you
this
so
is just
much.
the tip of the iceberg. As we dwell deeper and deeper into these laws, we'll probably find laws which are beneficial to the citizen, and others which will come with its own baggage of problems.
Okay. Thanks so much.
Thank you.